Thank you, Samson. I think I want to start by saying that in pure terms of technical effect, the committee did nothing wrong. It doesn't affect the legality of it in any way, that they did not grant an extension or that they did not send a consolidated report, because they are separate petitions which require separate conclusions. And while it may have been nice to have had all three together, there is nothing by way of error in them not choosing to do so. However, I'm going to have to agree with Nana Ajebua for that. The refusal to grant the extension was neither necessary nor prudent. I think, given the gravity of the situation and the gravity of its outcome, it was important for there to be no procedural doubts around it, to the extent possible, because as Honorable Hussaini pointed out, we are always with a new space with untried, constitutional provisions. So errors are bound to be made, but there are avoidable errors. And I think granting them, we've been 6 months down this road. I think one more week would not have hurt. That said, I don't think it actually invalidates anything. I just think it creates an unnecessary, if you like, noise around the committee's work, which it could have spared itself simply by giving them a week. As to the decision to send them individually, if I send a petition, I'm not quite sure why I should have to wait till somebody else's petition has been heard before I know what the outcome of mine is. So I can't fault that. The president's decision to act on the recommendations of that particular petition, as opposed to wait for the rest, again, it was a choice, but he was bound by the recommendation of that particular petition. So whether he waited or he didn't wait, he would have ended up doing the same thing, because he was bound. He is bound by the recommendations. It's not a discretionary choice to accept, or he can't issue a white paper saying, yeah, he thinks they've done a good job, but he's going to caution her and let her go, or whatever. He was bound, and therefore the decision to act, I think people are entitled to their opinions whether he should have waited or not. Was it necessary for him to wait? I don't think so. The process, and I do take Nana Ajebafo's point that the charges in the other petitions remain unresolved, and so she hasn't had a chance to prove her innocence. However, those petitions are supposed to be secret anyway. So if everybody had been doing their part in this journey, nobody leaking documents, and everybody respecting the constitutional provision on secrecy, then the unresolved nature of the petitions should not really affect the reputation of the respondent. The problem is that people haven't. But if everybody had done so, it should not matter. As a matter of public funds, this committee is sitting on public funds. They have heard one petition. They have heard it to its end. They have come to a conclusion on it. Their conclusion leads to a single position in law. They have sent the report on to the president. I'm not sure that the cost of public funds to continue the process, given that its conclusion was now set in stone once the committee's recommendations in Daniel Ofori were made, is justified. I do admit that if they had finished, at least we'd have a historical record. But I don't know that I would say that would justify the cost of the public purse. So
you are saying the chairman of the committee, Justice Gabriel Scott Portman, ended his speech to the president by saying, accordingly, we shall be reporting on the second and third petitions in due time. You are saying that yes, this has become otiose, we can't get to them anymore, it's waste of public funds if we go to them?
I think we can decide to carry on, but as Oliver points out, you are dealing with the removal of a chief justice, a petition to remove a chief justice who is no longer chief justice. So supposing we go through the process and we get to the end and the recommendation is that she should be removed, what action will the president take now?
Oh.
So then it will be a long and expensive process, so we know that she should have been removed 3 times, or she should have been removed only once, or twice she would have been removed. But so I'm not sure that there's any value to continuing it.
Right.
I think Justice Parman was correct to state that they would, they finished with petition 1. They have petition 2. They were charged to listen to 3 petitions because they don't remove the chief justice. That's not the committee's job. The committee's job is to hear the petitions and decide whether they meet the constitutional thresholds for removal and recommend same. That's their job in case of each petition. So supposing the president had decided to wait, the committee could carry on with its work.
There are a number of cases, suits that have been mounted on the back of this, including as pursued by the Chief Justice herself. And there's been commentary from left, right, center, including the Bar Council in England. Do you suspect that this was to preempt anything that could, have come out of any of those suits that are still pending, that they could have scuttled the committee's work, and that's why the committee decided to run fast with the first one?
Thompson, I'm not a political commentator. So I'm going to say that in constitutional matters, suspicions are irrelevant. Yeah. So I don't suspect. I deal with the constitutional law and the content.
And the Supreme Court says that a multitude of suspicions cannot constitute proof.
It cannot constitute proof or law. So I'm going to decline to speculate on the matter of why. The president, I will say, was completely within his rights to act, and he chose to do so. Had he not acted, the committee would have had 2 more petitions pending.
Okay.
But now that he has removed the CJ, there's no CJ to question.
Right.
There's
right.
no justice to question.
Let me get back to where I started, Aiko, to